The first major topic that I'm going to talk about is the coverage of the federal system compared to the state system. Previously, people covered under the federal system had to be generally what were called respondents to an award. You had to be joined as a party to an application before the Australian Industrial Relations Commission for an award. Sometimes people were joined individually, some particular employers. Often they were joined through their industry association. So you're a member of an industry association and you became a respondent to a federal award. That changed with work choices. Work choices changed the constitutional basis upon which the federal government made laws about industrial relations. Traditionally, the federal government used the powers to make laws in respect of industrial disputes extending beyond one state. Work choices changed that because it based the legislation on the powers to make laws with respect to corporations, trading and financial corporations. What's the practical effect of that? The practical effect was that the work choice legislation moved many employers from the state system into the federal system. The exact figures vary depending upon who was doing the calculations. But under the work choices legislation, somewhere between 75 and 80% of all employers in Australia were under the federal system. Previously, and again it varied from state to state and who did the counting, but it used to be about 50-50. So work choices changed that. It led to the difficult situation where some people who were what a lawyer calls a constitutional corporation were under the federal system, some people who were sole traders or trusts or partnerships stayed under the state system. That's changed. I've already mentioned this date, the 19th of November 2009. The New South Wales government announced the deal about industrial relations power going to the federal or being referred to the federal government. It's produced this. December 2009, an act achieving that was passed by the New South Wales Parliament. What's this mean? It means something is a little clearer and a little better in the industrial relations sphere, and it's this. The Fair Work Act applies generally, again this is a bit of a generalisation, but generally to all private employers in Australia, except for Western Australia. The classic exception that all lawyers have to say at the moment. Maybe that'll change. But all private employers are now under the federal system. It doesn't include, as you can imagine from that, state and local government. But it does include, for the first time, partnerships, trusts, sole traders, and there were some people who are working for not-for-profit organisations, and I know that there's some in that sector here tonight. There was an argument that they were still under the New South Wales system because they weren't a trading corporation in some circumstances. It's now almost certain that they're under indeed certain that they're under the federal system. So a simplification, something that the Australian society has been looking towards achieving for some time, and something that's actually to be celebrated. It's actually good news, because it means that people like me, a solicitor in private practice, doesn't ask someone who comes to see them, the first question is, are you a constitutional corporation? You can imagine asking that to people and see what they say. It means that it is, at least in terms of coverage, it is a simpler system, and that's something that should also be, to some degree, celebrated. Also means that the law in New South Wales and the law in Queensland for private employers is in harmony. So there's aspects of this which are good news, and I just wanted to mention that to you because it is.